Okay, ladies and gentlemen, we are going to get started. Thank you all so much for being here on this beautiful Friday morning. My name is Alexandra Gheciu. I am the director of CIPS, and on behalf of the center and myself, it is my great pleasure and privilege to welcome all of you to our conference on one of the most important and intensely debated issues in contemporary international relations. And of course, we're talking about the security challenges of emerging technologies. As you know, today's event is co-sponsored by CIPS and the Canadian Pugwash Group. And I would like to take this opportunity to thank the group for their wonderful work for today's event and for so many other events and projects over the years. And indeed, and as we organize this event, we are bringing back old friends. I am proud to mention our long, beautiful, and productive friendship with the CPG. I think many of you have been here. You know that over the years, we've organized many exciting events together. And I very much look forward to writing another chapter in this book of friendship today. As a prelude to today's event, I think we should know that we are meeting at a particularly important time. It's a time when, whether we're talking about cybersecurity or the ethical dilemmas of artificial intelligence, which is of course increasingly integrated into weapons systems, there is growing consensus among academics and policymakers in Canada and abroad that these technologies, while presenting immense potential, also pose increasingly complex security challenges. And so, to help us shed light on some of these challenges and their implications, we are very fortunate to welcome an exceptional set of panelists. I am deeply grateful to all of you, to all of our panelists and moderators, and indeed to the audience for accepting our invitation and joining us today. We have a full day of extremely interesting panels, so I hope you will stay until the end. And now, without further ado, I hope you will allow me to welcome to the floor my friend Cesar Jaramillo, who's the Executive Director of Project Plowshares and the Chair of the Canadian Pugwash Group. So thank you so much, and please take the floor.
Thank you so much, Alexandra, and good morning, everybody. I really appreciate the word of friendship. And I fully agree with it. And we're not just at CIPS, we're back at CIPS. And it's really a very productive and nurturing relationship over the years that we hope will continue. So thank you very much for your friendship, for the very productive collaboration. And thanks to every one of you for making the time to have a conversation today on these important topics. I was driving to Pearson Airport a couple of days ago from my home in Waterloo. And my mom calls on the Bluetooth, and she calls from Medellin, Colombia, where she lives. And she said, apparently she had been watching some news or something, she said, a bit of despair. She says, the world is falling apart. And in Spanish, el mundo se cae a pedazos. And I'm like, it certainly seems that way. You know, it's difficult times. And then she says, what are you going to do about it? And I'm like, okay. And I know she didn't mean you, me in particular. She meant us, you, a big you, a plural you. She meant us, informed people, policy experts, international security experts, specialists, people who know and should know better about these things. And the reason I gave it their answer, it wasn't in a self-serving or self-important sort of way. I wanted to be comforting, but I didn't want to lie to my mom. I did enough of that in my teens. And I do feel we have to do something about it, about the international security crisis, and the topic of today's conversation is only a part of that international security crisis, but we need to do something about it. We need to be responsive. And that is at the heart of what the Canadian Pugwash Group believes. This is not just an intellectual exercise. This is an effort to be responsive, to craft effective policy solutions, proposals, ideas creative paths forward, because the challenges are that dire and they require expertise. We're very, very lucky to have a lot of expertise in this room. We're very, very happy to partner with CIPS in this endeavor. How do we face these challenges? Now, we're at the dawn of a new era, and it isn't often that you get to say those words and mean them. You know, we're at the dawn of a new era, certainly from a technological perspective. You've all been familiar with ChatGPT and the news it has generated, and you have seen the program, where we're going to tackle everything from cyber to outer space, to artificial intelligence, to nuclear weapons, to a role for Canada. And I think that the approach that we take to this is very important. And central to many of these questions of new technologies is the question of humanity. And I was thinking about the Russell Einstein Manifesto, which is a foundational document for the Canadian Pugwash Group. And one of its perhaps most widely quoted lines is, remember your humanity and forget the rest. I think that human element is going to be central to all of our conversations today. Now, the topics at hand are rich, are lively. Some of them are controversial, but we have very, very well-positioned experts to comment on them. And one thing to note about these two technologies and these challenges that are associated with the emerging technologies and the rapidity with which many of these technologies are being integrated into military systems is that, yes, they are new challenges, but these are not challenges instead of the old ones. These are challenges in addition to the old ones. We still haven't solved nuclear weapons. We're still worrying about small arms and light weapons. We're still worrying about explosive weapons in populated areas. We're still worrying about protection of civilians. So arms control, traditional arms control from the past few decades, virtually every single issue remains unresolved. And on top of that, now we have issues of uncharted normative territory for cyber, for AI, for outer space security, for all of these things. So it's really a matter where the challenge is compounded. We still have to worry about the old, and now we need to tackle the new. But I believe firmly, and so does the Canadian Pugwash Group, that these challenges are not beyond the ability of the international community to tackle. They're not beyond human ingenuity. They're not beyond human creativity. There's bad ideas out there. Believe me, you all know this. But there's also good ideas that can counter them and that we can use to tackle some of these challenges. A particularly problematic or thorny matter or issue or dimension about new technologies is that they're not categorically or exclusively good or bad. Most of them have this multi-use or dual-use dimension. So you can use drones, for example, for search and rescue observation, for agricultural forecasting, but you can also use them for extrajudicial assassinations. You can use cyber advances for research, for medicine, for connecting with others, but also to cripple entire infrastructures. You can use outer space capabilities for arms control as a technical means of verification, for weather forecasting, for other benign uses, but you can also use outer space capabilities for military uses that could be detrimental. Nuclear weapons, I have nothing good to say about them. They are not multi-use, and the only conceivable result from the use of nuclear weapons is devastation and the killing of many. And of course, we're aware that we're in Canada. So a lot of this conversation, even though it applies internationally and has an international dimension and several stakeholders beyond Canada, for us, a primary interlocutor and stakeholder is the Government of Canada and Ottawa. And the question underlying many of our conversations is, what can Canada do about it? What will Canada do about it? Is Canada pulling its weight in a way that is going to be conducive to collective security? So hopefully, many of our conversations will be leading to that notion of Canada as a country that can and should be using all its powers and all its efforts and all the tools that are at its disposal to tackle these realities and the challenges that are emerging. I will leave it there because we're already late with the program, and because I know you're all eager to hear from our distinguished panelists. So without further ado, I'd like to invite the panelists from the first panel to take the table. Thank you.
As I said, my name is Nisha Shai. I'm a professor in the School of Political Studies here at the University of Ottawa. It is really my pleasure to chair this first panel. I think without further ado, we'll just get into the presentations. Did you have a preference? No. Well, maybe we'll start at the end of the table with Leah West from Carleton University. So she traveled very far to be here today. Our first panel, of course, is the kind of more familiar, perhaps, nexus of, or familiar frontier of emerging technologies, thinking about kind of cyber capabilities. So Leah, I'll just turn the floor over to you.
Thank you. So while talking about the familiar frontier, one thing I want to talk about that we don't often talk about is the defensive rules of international law and what obligations states have to defend their citizens from cyber attacks. And I want to explain essentially that how we've been thinking about this to date didn't survive first contact with our first full-scale conventional war. Russia's invasion of Ukraine in February 2022 did not begin with artillery fire or rolling tanks. It started with cyber attacks against Ukrainian cyber infrastructure. This opening salvo included attacks against Ukraine's broadband internet service provider and 19 government and critical infrastructure entities nationwide. These attacks were not unanticipated. Russian military strategy has incorporated preemptive cyber attacks since it invaded Georgia in 2008. And this strategy is a sound one. Like artillery and aerial bombardment, cyber attacks can prepare the battle space for ground troops by degrading, disrupting, or destroying key military objectives. However, unlike traditional fires, cyber attacks give users even greater operational reach and the opportunity to compromise the integrity of critical infrastructure in indirect and direct ways without a physical presence. This limits the immediate risk to man and material. Deploying cyber attacks before using Connect Force also provides a level of deniability. In anticipation of Russia's attacks, the government of Ukraine took unprecedented steps to defend its data and virtual cyber infrastructure. On the 17th of February, a week before Russia and Russia's attacks, the government of Ukraine, its parliament, amended its data protection laws, which had long prohibited government authorities from processing and storing data in public clouds. The result of those laws meant that the country ran its civil and military digital infrastructure on segregated servers physically located in government facilities within Ukraine's borders. This law also applied to select private sector data. Parliament amended the law to authorize what Microsoft called an evacuation of Ukraine's critical government data. Over the next 10 weeks, government information officers and staff, with the assistance of at least Microsoft and Amazon, migrated Ukraine's most important digital operations and data onto a public cloud hosted on private servers all across Europe. Consequently, Microsoft reports that Russian cyber and kinetic attacks against Ukraine government data centers and computer networks have had limited operational impact. As the conflict continued, additional data belonging to government entities, private sector companies like Ukraine's largest bank, Ukraine's universities, and their remote K-12 school that is serving displaced children was also moved online. The key to a country's digital resilience in wartime, touts Microsoft, is the ability to quickly move data outside the country while still connecting to and relying on it for a government's digital operations. The fact that we have Microsoft telling us about wartime strategy is itself a sign of the times to come. While this may prove to be true, it is less clear whether this strategy is actually consistent with international humanitarian law, the laws of war. During an armed conflict, state parties have legal obligations to defend civilians and civilian objects from the effects of cyber attacks that initiate or arise during an armed conflict. Unlike most laws of armed conflict, the rules governing precautions against attack don't simply prescribe or prohibit certain conduct during hostilities. They also create positive obligations on states to do one of two things: segregate civilians and civilian objects for military objectives, and where segregation is not possible, take other necessary precautions to protect them. To date, The academic literature on how this would apply in a cyber context has been largely theoretical, and scholars have conjured hypothetical examples to talk about how this would be done. And most of the literature argues that the best way to ensure compliance is to build entirely separate government and military data networks and ensure that civilian infrastructure is marked and easily identifiable. So essentially, the exact situation that happened prior to the war. And just this month, the International Committee of the Red Cross put out a series of recommendations on protecting civilians from digital harm and included the following. States should, to the maximum extent feasible, segment data and communications infrastructure used for military purposes from civilian ones, and tech companies should, to the maximum extent feasible, segment data and communications infrastructure they provide for military purposes from civilian ones. However, in the Ukraine confront, the exact opposite occurred. Ukraine, with the help of Microsoft, AWS, and others, interspersed its data with private data to protect its critical government operations, both civil and military. It has ceased relying on isolated government infrastructure in favor of civilian networks that Ukraine has no authority and seemingly no capacity to defend from further attack. In a sense, Ukraine is using private European data and infrastructure to shield itself from attack. So far, these precautionary measures have proven to be effective, but are they lawful? Now, I just want to back up and remind everyone that the core principle of IHL is that of distinction. I've already kind of mentioned that, and that is the need to distinguish between military objectives, so that which offers a definite military advantage, and civilian objects, so everything that's not a military objective. I know that what we're seeing in Israel and Gaza these days, it bears reminding that it is a principal rule of international law. And tied to that principle is that of precaution. And the specific rule says that parties to a conflict shall, to the maximum extent feasible, endeavor to remove the civilian population, individual civilians and civilian objects under their control from the vicinity of military objectives, avoid locating military objectives within or near densely populated areas, and C, take other necessary precautions to protect the civilian populations under their control against the dangers resulting from military operations. Now, a lot of the literature to date I could go through, and I'm not going to bore you because it's only interesting if you're an international law nerd, but the key debates around this rule and how it applies in cyber attack have focused to date on two issues. What amounts to a cyber attack? What amounts to an attack in cyberspace, right? Because most cyber attacks don't give rise to the same kind of level of physical violence or physical damage as a kinetic attack. So where do we draw that line? The second is object, military object versus civilian objects. Is data an object, right? There is a lot of debate about whether or not data actually qualifies as an object. If it's not an object, right, you can target it all you want. There's no rules against targeting non-objects, right? So it means you get to target it all you want. And you also don't have any obligations to defend it if it's not a civilian object. I honestly don't think either of those is really important in this context, because even if data is not an object, if an attack on it rises to the level of an attack, you still have obligations to defend your civilians against it because of the outcomes of the attack. So I'm going to set those two issues aside. The one question we've never talked about is, what does it mean in cyberspace for something to fall under a state's control? And usually, and the experts that were responsible for the Tallinn Manual, which is kind of the leading text on international law as it applies to cyberspace, were somewhat divided. The majority said, if it's in your territory, it's under your state's control. Okay. The minority said, well, when we're talking about information communications technology, it's really everything in your state within your control. Maybe you have to have more de facto control over it. So territory was a necessary but not sufficient qualifier. What happens when you have control over data and cyber infrastructure and it's not in your territory? This is essentially the situation we now find ourselves in. Under the leading expert's opinion, Ukraine no longer has any obligation to protect that civilian data whatsoever. its obligations ended the minute it migrated that data and all of its civilian and its operational technology, its operating systems onto servers in Europe. That can't be. But that's essentially where the law stands. So Ukraine fulfilled its obligations under international law to take that data and protect it, to segregate it from something that they knew would be attacked, done. But then they hid it in Europe. And let's think about that context in that if it wasn't data, if it was weapons, we're going to protect our arms and ammunitions by just hiding them in private gun ranges and homes and safes across Europe. That doesn't make any sense. And yet this is the context we have when we don't think about things in the context of the actual technology we're talking about. And we still have the ICRC continuing to make recommendations that the best way to deal with this is to just segregate your data inside your territory, and that's the best way to ensure its protection, to ensure the protection of civilians. When we realize that that's not actually the best way, we've just demonstrated that the best way is to hide it in plain sight in Europe. But that in and of itself creates all kinds of problems. Because what have we done? We've made all of those European servers, European private servers, that are in places like Madrid, Dublin, Paris, Milan, military objectives. Because if they have essential government functions or data that is essential to Ukraine government functions, that it is all qualifies as creating a direct military advantage. If they take it out, it can be targeted, regardless of where it is. Now, is Russia going to target servers in Europe, across Europe? Nothing has stopped them from targeting NATO countries since the war began in cyber attacks. So I say all of this not to say that how dare you Ukraine, or how dare you ICRC. My point is that we have to, when we're thinking about how we're applying rules, especially rules that are designed to defend civilians, we actually have to think about whether the recommendations we're giving are most likely to defend civilians and comply with international law. Because when we avoid actually thinking through the consequences of conflict and technology, and we just think in the abstract, right, we're going to get recommendations that don't survive first contact. And that's when states are more likely to operate in gray zone spaces that are not easily confined to the law, or where we can't shape state policy trying to use the language of the law. So I'll stop there. Thank you.
Right. Thank you, Leah. I'll now turn the floor over to Walter Dorn, who visits us from the Royal Military College and Canadian Forces College in Toronto.
Thank you.
Thank you.
Mic test.
Oh.
Great. It's so great to be among you again. I've lectured in this room before. It's a marvelous space that we're so grateful to the University of Ottawa for giving us, and to be here with my, if I can use the word, brethren in arms control and peace issues. I feel so at home in Pugwash ever since I was a undergraduate student in chemistry and physics. And some of those early moments helped fashion the career that I've been able to pursue ever since. One of those moments was learning about Elizabeth Mann Borghese, living in Nova Scotia, who came up with an idea as an NGO of global commons. She was promoting that the oceans are something that are the global commons. And this was floated in academic articles, and it was very much became a foundation stone for the UN Convention on the Law of the Sea, in which Canada played a major role in negotiating that with Ambassador Beasley. And those go to show me how you can have ideas, that there are ideas bubbling in civil society, and they make it up to the government level, that we can float ideas now, like were just presented by Leah, about the holes in international law and the ways to fill them. And the UN Convention on the Law of the Sea is just one example of how we managed to bring some governance to the ungoverned spaces. When I speak to my naval officers, I have 30 or 40 of them in the Joint Command and Staff program now. It would be inconceivable that they would operate without UNCLOS. It's such an important part of governing the sea and understanding the rules. And of course, now we're looking at the limits of the continental shelf, going to the commission established by UNCLOS to look at where the Canadian continental shelf goes to and how do you resolve disputes with Russia over that. So the oceans is one space that began to get some governance, and we actually have an international tribunal for the law of the sea, which can hear cases. Outer space is we'll be hearing about later, and it's a less governed space, but we do at least have an outer space treaty, 1967, I believe, and we have the basic rules, not much implementation machinery, but something there. Cyberspace is a new domain, and we haven't come into the realm of governance. It's been the Wild West, with some people, some organizations taking a leading role in creating governance because there was a huge vacuum there. If you ask who governs it, well, it's largely business. You'll learn about Microsoft's role in Ukraine and the important role that Microsoft has in guarding our system worldwide. But if Microsoft has a bad actor within it, or it has some objectives like, how about this, profit, then it can easily modify this space that belongs to humanity and use it for its own, or at least bias it towards its own purposes. And I've seen Microsoft do that many times as they're trying to gain more and more business through new areas, whether it be in the early days when Microsoft was trying to force you to use the Microsoft Internet Service provision for gaining access to the internet. So really, we can't see business doing it. One of the things I do is I take our colonel's course to New York, and we often bring them to Morgan Stanley, which is at the edge of Manhattan, looking towards the Statue of Liberty. And they have about 20 meters of screens where you're looking at cyber attacks in the world today. And they'll specify what kind of worm or virus is being attacked in different areas. And that the business does it for its own purposes. Now multiply that by hundreds of thousands of businesses that all have to do monitoring. You get a huge inefficiency in the way that you deal with this new space. So the business solution is going to be part of it. The CSIRTs and other kind of cooperative efforts are going to be part of it. The biggest actor now is actually the European Union, the supranational body. And they've established things like the GDPR, Global Data Protection Regulations, which have become global regulations, not regulations per se, but become a global standard because there's so much of the internet usage is in Europe, and so much passes through servers in Europe that Europe can actually set the standards because there's a lack in the United States. In fact, I remember when Bill Clinton had to make an early decision in the 1990s. What do we do about this new phenomenon called the World Wide Web? How do we regulate the internet? And he took the advice of businesses, which all said, don't regulate us. It was a big mistake, but we suffer the consequences in hacking and the wild west of the internet and the misuse by countries like China and Iran and of course Russia in this space. If we'd actually regulated it early on, we could have had a much more governed space. So all of these indications show us the same principle that was applied in the law of the sea, is applied in all of our global commons. That is, global problems require global solutions. And we need to have some means for regulating the internet globally. And so it comes to the UN. Any path to global governance goes through the UN, for better or for worse. And we obviously have to strengthen the UN, but there's going to be some need to have the nations of the world, as well as civil society, be able to have input into these forms of regulation. And so the UN has created an open-ended working group, came out with some important statements. Lots of governments, I sat in some of them in New York, and it can be very long and boring and tedious, but there are important principles coming out. They also had a group of governmental experts, the GGE, and one of the key principles of coming out of the GGE is that international humanitarian law, or the rules of armed conflict, apply in cyberspace. And that's not even accepted by all member states, despite the Talon Manual and other documents that spell out a lot of this law. And there's a NATO COE, Center of Excellence on Cyber Defense, where you're trying to create some of the legal measurements, some of the rules and accountability mechanisms there. But it's still, we don't yet have the treaty that's necessary to be able to do the regulation like UNCLOS did for the sea. So in this wild west of this global commons, I asked myself, well, what are the other areas where the UN could apply some of what they've learned in conflict resolution? And I asked myself, could peacekeeping apply? Could the principles of peacekeeping apply in cyberspace? Can you actually deploy cyber peacekeepers? And a little bit of thought into the matter showed that there's a lot of scope for that concept. That actually all of the actions in peacekeeping can apply in cyberspace, but in a different fashion. So first of all, we need a monitor. We need to be able to monitor cyberspace, or if there's a specific areas or countries or domains in the cyberspace that are being targeted, we need somebody to monitor that. Somebody impartial who can actually come up with factual based evidence, including the extent to which you can do attribution. And so monitoring is one area. If there is a conflict between two countries in the physical domain, and you are having a physical peacekeeping force in that domain, let's talk about Syria, Israel, or Lebanon, Israel, or Hezbollah and these areas. Where do we get the facts? There are physical peacekeepers on the ground, and they're also being hacked. So they need to have a UN capacity to detect attacks. And then what do you do in cyberspace when it becomes a cyber war? Instead of saying, well, we're going to attack the Hamas bases, or we're going to attack, take Israeli hostages, what about if they decide we're going to attack the infrastructure, the cyber infrastructure, or pay someone else to do that, as has happened before with Hezbollah, contracting out some cyber hacking. So we need to be able to have this monitoring function and know at least what's going on. But more than that, the UN has buffer zones, like in UNDOF, the UN Disengagement Observer Force, located in the Golan Heights, part of Syria, with an Israeli side and a Syrian side. So you create a buffer zone that physically separates them. You can do similar things online. You can create cyber layers, which you can look at the traffic going in and out. And it's very important to monitor this traffic because there will be hacking in there, but there's also the danger that there are going to be international incidents. And I'll give you an example. One time, China, by accident, so they say, managed to get the border gateway protocol into Europe. So the cell phone traffic coming into Europe was for several hours going through China. And you can imagine what kind of intelligence you could get from being able to acquire that. So we need monitoring of things like the GDP, Global Border Gateway Protocol, and be able to take some measure of layering so that you can do these protections. And if a country is attacked, well, and the country comes to the UN, and Secretary General said, look, we've been attacked, our servers are down, can you help us? Well, the Secretary General actually used the example of Senegal came to me, what would I do? And that was part of a UN exercise to look at where the capacity is in the UN. So we went to the ITU, we looked in the UN Secretariat. We found out there were only about 100 people who could actually help in that case on an emergency response. There's a huge need there for increasing capacity of the UN Secretariat and the global community to respond to these kind of actions to make the UN an effective organization. A kind of like International Atomic Energy Agency, you see Tariq sitting right here, IAEA capacity to be able to help the development of the rules of cyberspace, just as the IAEA did for nuclear power, and be able to do inspections, and that would be like monitoring, and be able to do some of the peacekeeping tasks. So I end with the usual phrase of global problems require global solutions, and global cyberspace requires some global cyberspace mechanisms and capacity. Thank you.
All right. Thank you to both Leah and to Walter. And I think both of these presentations, I think, raise this really interesting question of how do we think about compliance with international law or international humanitarian law when that law was imagined in a different historical context, and in fact, imagined with a different normative place and justification for war in the international system? How do we think about international law when it isn't just states who are the brokers of war and security today? And I think there are several important questions that were raised by both of your presentations. The first, explicitly addressed by Leah, is how do we define a civilian object, right? And there's this history in IHL that you outlined really well about the principle of distinction, but the principle of distinction initially didn't even care about civilians per se. It was about non-military objects or non-military personnel, really about medics. And the wounded, medics attending to wounded soldiers. Then the principle of proportionality emerges in the kind of late 20th century. And I think there's actually a distinction between this idea that we think IHL defends civilians and civilian objects, but also protects civilian objects. There's a very different, I think, logistical and normative thing between thinking about defending civilians and also protecting civilian objects or infrastructure that I think we haven't fully unpacked in terms of how we think about how civil society is thinking about it, and also how militaries are thinking about the role of the civilian. Then there's this question about the kind of material structure of the theater of operations that I think, Walter, you're getting at, in terms of, well, when we start thinking about global problems needing global solutions, this idea of a global commons is really interesting. I think we might all agree that this is a global problem, but the commons implies a totally different set of commitments that getting agreement on that, I think, would be much more difficult. And then when we put this in the context of Leah's discussion of moving data to different servers, right, our questions of responsibility, of which authorities in which places are held accountable totally changes. So our understanding of network-centric warfare is totally different in this context. So I think these are really kind of the questions you're raising are both based in really important empirical observations, but they're raising really important conceptual problems in how we think about the regulatory landscape for cyber technologies. So I'm going to open the floor now to comments and questions. Can I ask that you please introduce yourself so that we can be familiar with who's in the audience today? So there are two questions in the back. So I'll start in the back there, then here, then, oh, do we have a mic? Oh my God. Okay, can we please line up? I didn't see that, sorry. Yeah, sorry.
No, it seems to be on.
Yes.
Well, thank you, Leah, Walter, for those presentations. They raised so many issues. My name is Paul Meyer, Canadian Pugwash Director. Question for Leah. Has there been any evolution in the thinking regarding cyber operations and the prohibition on the use of force in the UN Charter? Whether an offensive cyber operation is deemed a use of force. And then for both Leah and Walter, as you may know, there's been progress in some efforts at establishing a normative framework for cyber activity by states. It was agreed back in 2015 and has a number of restraint measures that I think we would all acknowledge would be healthy. At the same time, compliance has been rather scanty and checkered. So my question to both of you in that regard is, How do you think that normative framework can be enhanced? Particularly, how can compliance by states be encouraged? Thank you.
So on the use of force, there has been some evolution. Essentially, what we've started to see in terms of evolution on this question and others, kind of the core questions around international law as applies to cyberstates, is states have started to make pronunciations on how they view the law applying and how they interpret. So Canada, for example, in May of 2022, it was like 2 weeks after my kid was born, and I'd been yelling about this for years, and I felt that they were doing it to spite me, finally put out its statement on how international law applies to cyberspace. And one of those things is, well, what does it mean to be a use of force? And so essentially what we're seeing is an understanding where if the effects give rise to what we would account as a use of force in the physical space, it's a use of force. The interesting questions aren't really around the threshold for use of force in armed attack, because we're starting to see some coalescence around there. The really interesting question is at the lower level. So what is a violation of sovereignty in cyberspace? So that's where we're seeing it, because states are trying to preserve their ability to engage in low-level cyber operations, so cyber espionage, for example, without saying that they're engaged in a violation of sovereignty that could lead to countermeasures, et cetera. So you're getting pronunciations that from Canada even that you can come and poke around in my systems, and that's not a violation of sovereignty. But if you start messing around with it such that things stop working, now you've violated my sovereignty. But that's a weird, which no one would ever say in the physical space. No one would ever invite a spy in and be like, here, poke around if you like. Mm-hmm. Not a violation of my sovereignty, but just, don't take a hammer to my computer. So I think that's the more interesting question, because there's so much in the cyber realm that happens below that. We've created physical damage space. That's where most of the work is done in cyber. And that's where we're seeing states not in agreement. And I'll turn over to you.
Yeah, sir. I think that's a good answer. And follow on the use of force. We need new rules, because obviously using analogies isn't sufficient. We need to be able to prevent cyber attacks. And whether it's a use of force or not, it needs to be prevented. We need to be able to regulate that ungoverned space. And the norms that you spoke about, Paul, those are not sufficient. It's progress, and it shows hope. But at the same time, we need a treaty. We need a treaty with binding mechanisms. We need institutions to enforce the treaty and also to implement it. So the chairman, former president of Microsoft, was calling for cyber Geneva conventions. So it would be modeled on the Geneva Convention, or at least inspired by, like some films say, inspired by a true story. Well, this would be inspired by but you're not going to say we're going to take the Geneva Conventions and apply them in cyberspace, because there's just so much uncertainty about how you do that transfer. And I think with the cyber Geneva Conventions, you can allow your imagination to go. You might want an ICRC equivalent, some body that isn't purely governmental, that can help be the custodian, as the ICRC calls itself, of IHL, or the Geneva Conventions in particular. So I think that there's lots of room there for inspiration, but we need customized law, including treaty law. And we actually need enforcement mechanisms whereby you'd have some sort of international authority that can actually have keys to go into some national capacities, so that you can actually do the inspections, that it's not just relying on nations to enforce their own laws. You can imagine Iran and China and Russia not being, who are actually promoting cyber hacks, that we have some mechanism by which you give the capacity. And it is possible, because cyberspace is so universal. It's hard to say, okay, we're going to keep our narrow part blocked off, but you can create these mechanisms that actually is an advantage in cyberspace for verification and compliance mechanisms.
Okay, thank you. I invite the next.
You may have answered in part or maybe in full. This is a lot to digest. And I have to apologize for having been late and not caught all of Ms. West's presentation. But in the law, there's from what cases I followed, it sometimes seems to be what is the intent of the law, and a judge will interpret that. In other cases, it's a matter of explicit definitions. So I want to just lay the groundwork on offense and defense, and then functionality of targets and whether this is being addressed. And whether the difference between civil actors and explicitly governmental actors. Because, for example, in terms of governmental versus civil, if you go back 200 years ago, some crowns, thrones, would give, I think it was called a letter of marque to pirates, civilian actors. But it was the crown would recognize wreak hell and havoc, just not on our ships. So, and then in the fuzzy on the other, in terms of the defense, the civil versus the government, and I'm wondering if it may be more useful to talk about the consequence. So, for example, in seeing hospitals are alternatively owned by governments and some private. But in terms of criminal activity, which maybe is a letter of marque, privateers, some hospitals have been shut down by ransomware. And so there, it's a civilian target, but it's a matter of life and death in terms of what systems may be closed when doctors are operating and trying to check people's medical records. So I don't know if you can help me to understand what's being discussed with all these fuzzy and alternative definitions.
Yeah, sure. So international humanitarian law applies to all parties. So whether or not they're states or non-state actors, and it also applies to civilians who directly participate in hostilities and non-state armed groups. So all the rules apply. They just apply slightly differently. But in the context of, say, letters of marque, take, for example, vigilante hackers, right, in Ukraine. Right, who hacked back against Russia. They're civilians, totally civilian. They're not even necessarily doing it with the approval or a letter of marque from the government of Ukraine. But if they're doing it to advance the ends of the Ukraine military objectives at the detriment to the Russian military, they're considered directly participating in hostilities, which means they can be targeted and killed just like any other combatant. And they don't benefit from prisoner of war status, for example. So that is one of the interesting things about the cyberspace realm is that it's very easy for civilians to become directly participating in hostilities. And I'll give you another example. There's the EPO app in Ukraine, which is essentially an app developed by the Ukrainian government asking civilians to take photos of Russian armament, aircraft, etc., when they see it, and uploading it into this app so that then the Ukrainian military can respond. While they're doing that, they are directly participating in hostilities. That makes them targetable. So it's an interesting thing about how easily, right, simply downloading an app with the intention of doing it can make you somebody that's targetable in an armed conflict. So that's another element of this cyber domain issue and the digital landscape that we're living in that really changes the nature of who's participating.
So I would temper what Leah said, that these are legal opinions at this point.
Yes.
We don't really know how it actually applies. What we need is jurisprudence. We need courts to be able to look at this. And of course, yes, mens rea, intent will come into the factor in these sort of things. So that's one more reason for the international machinery required that we actually get some good case law in there.
All right, thank you.
Hi, Jessica West of Project Plushers, and no relation to Leah West.
Yeah.
That I
wouldn't
know.
object.
That I know. This was fascinating because we're having a lot of these discussions about the Wild West, as you say, Wild West of cyber in outer space. And so, Leah, the example you used of Ukraine, whereby their broadband capabilities were targeted, well, those were provided by a commercial satellite operator, Viasat. But Viasat didn't just provide command and control capabilities to Ukraine. They're a global service provider. And so that attack rippled throughout Europe. It took down roughly 75 German turbines that are used for electricity generation. And so cyber is sort of a soft underbelly of a soft underbelly, which is outer space. But these capabilities in space are networked around the world. They rarely serve one client or one country, and you don't know everything that they're doing because they provide data, and data is extremely fungible. So we have the same situation with the ICRC saying, well, systems should be segregated, except that that ship has sailed.
Yeah.
The world relies on GPS, which is a military system. Same with Beidou in China. Russia's Glasgow, also a military system. Europe's the only one with a purely civilian system. And also that we should identify civilian capabilities in space. But again, almost everything in space is dual use. But I would say we have another challenge, and this is what I would like you to weigh in on, which is the growing commercial participation, the clamoring to participate in armed conflict by commercial operators, if you will. So I was just at an industry meetings this week, and clamoring is the right word. You know, we do this better than the military. Let us do all your EO, let us do your comms, and also getting involved in third-party conflicts such as Ukraine. And then there's outrage when Russia very publicly and repeatedly says, you know, these commercial satellites are targetable because they're participating in conflict. And we're like, oh, how could you say that? That's terrible. And so what should we be thinking about, or what should commercial know? Because these are commercial operators. They also have lots of commercial civilian clients, and yet they're clamoring to be participating in armed conflict. And I feel like they probably haven't thought through a lot of the legal implications. They're aware they're constantly targeted by cyber attacks, the computer systems, we know that. And they're like, yeah, we could deal with it. And yet there could be consequences for civilians. Could there not be? And I'm just curious about, you know, what kind of questions should we be asking, and what kind of things should they know about before they dive wholeheartedly into dual use participation in armed conflict?
Yeah. So all of that I agree with. I think it's really interesting because the ICRC recommendations I just mentioned included, for the first time, recommendations for the tech industry, right? Like it had recommendations for parties, recommendations for states, and recommendations for tech, and then also had recommendations for everyone. And I was like, yes. And a big part of that was states, when they're asking for help from tech, need to make sure that they're communicating to those industry partners that, hey, direct participation in hostilities is a thing. You can now be targeted. And also one of the recommendations was making sure that tech was aware that it can be targeted. And so part of that is, I would say, making sure that tech does segregate their civilian and military systems to the extent possible, so that they can, again, and this goes back to the segregation idea, but I think that stops working when we're talking about data. That's really hard to do, but in terms of the hardware, I mean, we can still start to do that. But I think knowledge and like tech needs to make themselves aware that they're also putting their employees at risk. So what is the due diligence to their employees, their obligations as well, which I don't know that anyone's really thinking through. And so I kind of want to ask Microsoft and Starlink and everybody's like, you know, you're making your civilian employees targetable, right? So I think that's another conversation that needs to be had as well.
Yeah, very quickly. I think we might see this if Russia arrests some business people and puts them on trial. And I think this could be this IHL notion of that you can be a combatant if you're taking pictures could be something that shows the world that we need to create a separate set of rules, that we can't just apply IHL in the space of cyber. And we need to get some mechanisms so that it's not the principles are not abused, because ideally you want to just separate data from physical action. You know, just create a different set of rules and don't just tag them on to the current IHL.
Thank you.
Thank you, Nisha, and thank you, Walter and Leah, for a fascinating panel. So a couple of brief questions. The first is about attribution and deniability. And I think we've all seen the images of the hospital in Gaza that was bombed a few days ago. And there's fire, explosions, bodies, video footage, satellite imagery, and still the question of attribution is contentious. And the question of deniability is, front and center there. So one would imagine that in the case of cyber operations, it's even more pronounced, this question of attribution or misattribution, and potentially retaliating against the wrong country or target, or whether it happens to be from within a country but not the government. I mean, those sorts of questions seem quite complex in terms of the appropriate response. So yeah, generally speaking, if you can comment on that challenge of attribution and deniability. The second question, just to be clear, IHL, would you agree that IHL today does not suffice to address the challenges that we're dealing with in the cyber realm? And the reason I ask, in some of the other files that we cover at Project Cloudshare with my colleagues on lethal autonomous weapon systems, explosive weapons in populated areas, etc., we often hear, oh, there's already IHL. And we have some disagreements with that, because the circumstances have evolved, technologies have evolved, etc. But that's a common refrain we hear. Oh, we already have IHL. It covers anything and everything, sort of thing. Is it more clear-cut in the case of cyber? Like, oh, IHL is good, but it's most definitely not enough. We need new regulation and a new normative regime. Thank you.
Sure. So yes, attribution is extremely difficult in cyberspace. You can have VPNs and all kinds of networks that can hide things. You have the dark web, you have Tors and mechanisms that were created deliberately keep people's action private, and all the encryption mechanisms. But that's not to say that it's impossible. And what you can see is systemic behavior by a party. You can start to point to that. And there are cases where there are actually arrest warrants for people who are acting wrongly in cyberspace in many different countries. One example is the actions of the trolls in the 2016 election. The US actually indicted Russians, individuals working for Prigozhin, the late Evgeny Prigozhin. And you're able to get some data. So just like the police have to do their investigations, so you'd have to have this forensic, cyber forensic type of capacity to be able to dig into these things. And where you have repeated patterns where people make little mistakes. For instance, somebody who stole 50,000 Bitcoins, which is now worth $3 billion, was actually found. The reason is that someone broke into his house and stole some activities. The police went in and they were able to get information about what he was doing, and then was able to find out where he had these little microchips hidden, where he had some of the Bitcoins information stored on that. So it's not impossible, but it's a huge challenge.
Is IHL sufficient? I have a hard time saying no, only because I don't want that to be an excuse not to apply it or work to apply it in this context. That to me is the fear of saying, well, IHL doesn't work, and then people not thinking through IHL when they engage in cyber operations. I think it is sufficient to certain extents, but we need to do a better job of actually, thinking through these issues beyond the textbook and putting them in the context of actual how the tech evolves. Now, I think most people like me who work in cyber and IHL are under the impression we're not getting a new treaty anytime soon. And that's why we're so dedicated to working on improving our understanding of how we apply old law to new tech. And we're committed to that process because of issues of whether or not it's a commons or not, states are very reticent to come to the table and give up certain rights in cyberspace. My fear is that it's going to take a never again type cyber incident to get us to a place where we're ready to have a cyber Geneva Convention. I fear that, but I honestly can't see a way forward that doesn't involve something like that because there's just no move to bring states to the table right now.
Thank you very much to both of you.
There are
Oh, because on IHL, if I may, just before, I mean, you commented earlier, Leah, very interestingly on distinction and the centrality of this distinction. I was thinking also, and I agree fully, proportionality and the notion of cross-domain escalation. And the simplistic example is like if you had, if my systems are vulnerable to attack on you know, with cyber capabilities, and I blow up a bridge of yours with a kinetic attack, would that be deemed escalatory? Or I mean, is there a way to assess proportionality when it's a matter of cross-domain escalation?
So, I mean, escalation is not really an issue once you're already into an armed conflict. Whether or not something is proportionate is based on the military advantage and the loss to non-military objectives or civilian objects. So it doesn't really matter what the object is, whether it's a cyber object or a kinetic or a physical object. You have to engage in that proportionality analysis of the military necessity versus the loss to civilian life or non-military objectives, and that applies. The proportionality analysis that you talk about escalation is important in the context of self-defense. So if you're attacked by a cyber attack, you can take steps necessary to defend yourself, and it has to be necessary and proportionate to repelling that attack. So in that case, that's where you have to kind of do this weird math of, is a physical kinetic attack proportionate and necessary to responding that cyber attack?
Thank you. My name is Paul Pugwash and ex-military. What I'd like to say is I think we are blurring the line between what's a combatant and what isn't. They don't wear uniforms anymore, and we have this problem. So we're going to have to get past this. Well, what my question is do we really have a plan B here? Because the way I see data, or we see data, is that there's certain resident data, which is logistics and everything that you put on these servers. And we may be getting to the point like we used to do with codes, that they change every 30 seconds or 2 minutes or whatever. So you could bounce data off Europe, and 2 minutes later it's in Singapore or Mexico, and do it all sorts of ways. We got to quad redundancy at one point in some aircraft systems. But I think we have a very small window with regards to protection. You know, agile data is one thing, but now that we're coming along online with quantum computing, there is going to be no password protection or anything like this. So we have to look at other mechanisms to do this. Logistics data is one thing, but there's real-time data that has a longevity and a utility of, say, a few milliseconds, getting information to a drone or targeting or command and control. You know, and it's like attacking a teacup that doesn't have tea in it yet. You're in that kind of quandary. So with quantum AI and all these kinds of things, I can see some military units now are starting to reteach map and compass stuff, you know, semaphore stuff. So they have trying to understand that this is coming down the line. Do you have any comments about longevity here?
Sure. Okay. So in CAF, I have some students who are officially called cyber operators. It is a new category of skill in Canadian Armed Forces. This, you know, they have the same levels of promotion as in the Canadian Forces ranks and everything like that, but it's really quite different domain in which they're operating. So it's a whole new considerations of what governs their actions and what they can and can't do. And you know that recently, about 2 years ago, we got a bill that allowed us to do offensive operations. CSE, the Communication Security Establishment, has used them in the past, but now it's much more, the legality of it is clear that Canada can respond with offensive means.
As long as they're compliant with international law.
Yeah, okay, and I appreciate that. And I would say that, yeah, the IHL regime that we have now is the best provisional regime that we have. While we're getting something better, let's use what we currently have to be able to create some guardrails from what can be done.
No, I think we're going to be revisiting this conversation again in 10 and 15 years. And that's the thing why I think a lot of states are hesitant to actually come out and make statements about where they've landed about how the law is. And a lot of them are hedging. Like Canada hedged a really long time because we want to know, we don't want to tell ourselves we can't do things that we want to be able to do. And we don't know if we want to be able to do them yet because we're not doing it. We're not doing it on a massive scale. So that's also why we're not seeing coalescence around some of these issues. Is there's a lot of hedging going on because the technology is evolving so quickly. And I don't think that's going to stop.
Right. Sorry, there is a question actually before you. Oh, are you sure?
I'm going to take both. And then
Hello, my name is Benji. I work in
Can you,
international cybersecurity
talk more into the mic, sir.
unit in global affairs. So my team actually is the UN delegate for cyber stuff. Walter, you mentioned there's a demand for legal binding treaties and institutions that looks like IAEA, that does the inspections and everything. I wondered, are you talking about the cybersecurity aspects or cybercrime aspects, that like the act that has been done, or act that states are trying to do or like will be doing? I think there's a big distinction between that, and I wondered if you have thoughts on that, like state responsible behavior and cybercrime that actually has been done, and where it has to be responsible, that where states has to be responsible for it. I think.
Yeah, great. And I will compliment, when I was in the open-ended work group, I saw a lot of creative work by your colleagues, and I heard other nations refer to Canadian proposals. So we are a little bit ahead of most nations on that. What I would like is regulation across the board. So it's very broad. You have to take a comprehensive approach if you're going to deal with similar like the law of the sea. So the crimes would be one thing. Now, as in most international law, the areas where we're the most advanced in implementation machinery and in laws is in mass atrocity. So I can imagine that this is a similar sort of thing, that in cyberspace, we'll get some laws that cover the worst types of attack first. Similarly, the International Criminal Court, the only court where we can individually bring someone to justice on the international level, deals with mass atrocities. It deals with crimes against humanity, war crimes, genocide, etc. So I imagine that we'd start with the more severe types.
We do have an international cybercrime convention, and that's the only treaty that exists that deals with cyber. But essentially what it does, it says, it tells states who are signatories that they have to have certain criminal offenses on the books and then certain capacities to investigate those offenses. And we could be holding states accountable for not prosecuting those crimes that they've signed on to have. But we don't really see that. We haven't really seen that at the international level.
Thank you.
I'm going to ask an obvious question, which hopefully has an obvious answer. Just on this question of IHL, or do you need something else? It seems to me that virtually all of the campaigns that many people in this room have been involved in, including anti-personnel mines, cluster munitions, nuclear weapons, where there are treaties or draft treaties or conventions, they're all based on IHL. I mean, the assumption has always been in each that in the background we have these obligations, but they're not being implemented or they're not being respected, and therefore we need new treaties to highlight the IHL as they refer to the specific weapons. I often say there's, none of these treaties, these new treaties are actually necessary if people followed IHL. So the reasoning why we have to go there is because of the failures of states. So if you can just comment a little bit on, do you not also see that virtually every one of these treaties that we're talking about that exist or don't exist are already based on IHL? There's no competition here. It's just to reinforce existing IHL.
Yes and no. And the reason I'll say no is because there's very few outright prohibitions in IHL. There's always a level of proportionality. And I mean, that's why the International Court of Justice has never said that law prohibits the use of nuclear weapons, because potentially there could be a situation where it would be proportional to use one. And so I think like the anti-personnel landmines, chemical weapons, biological weapons, those are important because they say, no, even if you can come up with an equation, we're saying, no, we're taking these off the table because of the suffering. And I think that's why they're important.
Yeah. Follow that up. So have there been cases where states have actually used the wiggle room in IHL in order to use, say anti-personnel mines for sake of argument? Now we went from IHL to actually banning weapons for those who signed the treaty, that is. Have states ever said, oh no, you can use these disproportionately? No, they would never say that. Or that the victims are, post-war are primarily civilians, and therefore that's okay because we use them for military purposes. Do they ever use those?
I mean, the United States continues to use anti-personnel landmines, for example, in the demilitarized zone and elsewhere. And part of the argument against them is that they're indiscriminate. And the argument is in the demilitarized zone, no, they're not, because there's no civilians, right? Like it's not going to be indiscriminately used. So there's like always this calculation that you can come to. And the other thing, if anybody's interested, the National Post just did a really good primer on how international law applies into Gaza and Hamas that I commented on along with Brian Cox and others. And it's important to remember that IHL isn't really designed to protect civilians. That's not actually the point. And so, whereas I see these other treaties, that is their purpose, right? To protect civilians, to protect even combatants from the suffering that could be caused by the use of those weapons.
Right. So I think that IHL is not enough. We need something much broader to look at it, because there's such, not only in addition to wiggle room, there's lots of categories where you're not sure whether it's an armed conflict. So IHL is the rules of armed conflict, and there's state and non-state armed conflict, and even that, is really open to interpretation. So for a lot of cyberspace, we need rules to deal with hacking and national and business behavior and individual behavior. So what's really needed is something much more broad than just the IHL example.
Right. Final question here.
Thanks. Tarek Rauf, Canadian Pugwash, and also former IAEA. So I had one brief comment, and I want to pause. Okay. And I wanted to.
Hold on.
I think.
It's just the up and down button.
Maybe it's battery. You want to take this one?
Okay. So I had a brief comment, and I want to posit two actual instances that came up before us at the IAEA, and I wanted your assessment of that. So my brief comment is that it's reported that the Chinese, the Russians, and the Americans have all been targeting each other's critical infrastructure to find weak points. So if and when they needed to go in there to destroy something, they would do it. So in that sense, pretty much it's a level playing field. So let me give you the first instance. Sometime back, a very senior executive from one of the world's most recognizable big IT companies approached us at the IAEA and proposed that concerning a nuclear program of a particular country, if we could identify the key scientists and the key facilities, they would help target the scientists and the facilities to try to corrupt their data or take over the ICUs. And to do us a favor, they could also install on our inspection equipment certain software. So when we took it into the facility, the software would find its way into the ICUs of that operating facility and then could report back to us. And then the last one, which is the kicker, he said that in time, with face recognition, we could develop technology, and this is an exact quote, to shoot them right between the eyes. And we said, sorry, we're not in that line of business, but the fact is that people are thinking about this, and I was wondering what your view was. And then second, we actually have an incident where we have a state-on-state attack on a critical facility, and that is the Iranian uranium enrichment facility at Natanz, where you know the 2 or 3 types of virus attacks that crippled it periodic for a while, but it also escaped and affected other people's Siemens ICUs. So again, I'd like what your views might be on that and how we could either regulate or deal with this, because a good actor today might be tomorrow's bad actor or vice versa, and things keep on changing all the time. Thank you.
So in the case of Stuxnet, for example, the interesting thing is it's not recognized as an armed conflict. So the rules of IHL don't apply. So what you have there is a use of force or an armed attack. And Stuxnet is the only example that most people point to as giving rise to the level of damage that could amount to an armed attack, which would have allowed Iran to respond in self-defense using kinetic means. So about whether it spreads or not, in an armed conflict, we have issues around proportionality and the indiscriminate nature of weapons that we need to think about. But in that case, it goes just kind of to the level of attack or assessing whether or not you've got an armed attack. So it's 2 different contexts. For your first example, that's frightening. And I think obviously they don't understand the role of the IEA to be thinking that you are going to participate in the espionage against a state or taking down a state. So that in itself is problematic. And I think, that to me was the strongest thing. They would think that an international monitoring body would engage in that kind of behavior is the thing that struck me the most about that.
Yeah, and considerations of this critical infrastructure, especially here in Pugwash, where we're so used to dealing with the concepts and the flaws of mutually assured destruction on nuclear side with nuclear weapons. Similarly, Russia has gone into U.S. critical infrastructure and put in means that they could cause dams to fail and lots of huge physical damage. And oil pipelines, we saw that was a Colonial pipeline that was hacked. And the way the U.S. responded was that they put in bugs into the Russian infrastructure. So we have a mad situation with all the benefits and flaws, and eventually major flaws that will come out with, because it's like mutually assured destruction. In the longer period of time, the danger of accident, miscalculation, unintentional actions could cause some much larger consequences. So very dangerous. I think we should have a basic agreement that nuclear power plants should not be hacked. I mean, we probably could get something on that, because the fear of danger of that is so big, and people realize that it's really a transnational threat. That if something like a Chernobyl were to happen, that it would affect the whole region and affect the world. So there's hope there. And on Stuxnet, I also see it as very much like we're in the Wild West of cyberspace. The good guys, the cowboys with the white hats, have done something, and you think, okay, well, it was good that they did that, preventing Iran from getting nuclear enrichment faster. But at the same time, that's not a way to have the future. You got to do the same thing that happened in the Wild West, is that you have federal enforcement. You need some sort of mechanisms by which you can create rules, and anybody who breaks them is held accountable. So again, back a call for global treaty and global mechanisms and institutions to deal with the cyberspace.
I just want to add one point on the critical infrastructure. There's something called the Oxford Principles that developed over the course of the pandemic. And it's just another sign of civil society taking the role where states are not, which is a bunch of international lawyers like myself who have tried to put into words core principles, core prohibitions that beyond kind of IHL, like you will not attack hospitals for cyber attack or healthcare data, like this kind of like core prohibitions that we don't see in IHL, and trying to spell them out and get states to buy into them.
Okay, I'm keeping an eye on clock, so this will be the very final question.
it'll be very-
And I'll ask everyone to keep their comments brief so that the program is not
It'll be
delayed.
very, very quick. I just wanted to ask a very quick, my name's Arndt Jorgensen. I'm with Science for Peace and teach at U of T. Follow up to Tariq's question. It seems to me that the prohibition on landmines and on chemical weapons and on cluster munitions and so on all derive from the unintended consequences of those weapons to civilians subsequent to a conflict. And to me, it seems that what Tariq mentioned of the Stuxnet has a similar kind of a dimension insofar as that there was an intentional attack on a target in Iran, but then unintended consequences that spread from the virus, in this case, spreading into all sorts of other realms. And could that be the basis upon forming a more comprehensive treaty that deals with this issue, somewhat akin to the Landmines Treaty and a prohibition of chemical weapons and so on?
Sure.
They don't invite me to the UN because Russia bans me. So
All right.
yeah,
Huh.
you go.
Interesting. Well, Russia couldn't stop you from going to the UN in New York. But
Yeah.
anyhow, I think that, yeah, we can get a lot of inspiration from these arms control treaties. But in cyberspace, there's far stronger dual use. I mean, in the Chemical Weapons Convention, we have a strong dual use provisions, and it had to do a lot of sorting out through schedules what's possible and what's not. What is a chemical weapons schedule? 1, 2, 3. But in cyberspace, it's not just a object or even a tool, it's a whole domain. It's what the military calls a domain. So we have land, sea, and air. Now we have cyber. Cyber is a domain. So the arms control treaties can be inspiration, but we need something much larger.
That's why I think more about the Oxford principles might be workable, where we just have outright prohibitions on targets as opposed to types of tools or weapons in cyberspace, because of that dual use issue.
All right, I want to thank Leah and Walter. I've been asked to provide some substantive comments, but I'm just going to leave us with 2 questions that I hope will apply to the conversations moving forward. One, I think, is there's this really interesting question about segregation. When we're talking about cyber warfare or this domain, how do we segregate? How do we, it seems to me that dual use doesn't really apply here. This also raises the question of how do we balance intentionality versus effect? We often talk about intentionality. Who is intentional when we're seeing like distributed effects on a critical infrastructure? I think this question about law is really interesting, because one of the things we have to remember is that while international law or international humanitarian law serves to act as a limit on the use of force, it also licenses the use of force. It creates that space of physical damage. And cyber technologies and many of the emerging technologies we'll talk about today are raising questions about what are the community of relevant actors willing to accept, not just as prohibitions, but what kind of use of force is permissible. And international law doesn't actually have a precise definition of what is a weapon. So as much as these conversations about how do we limit the use of force, there are also processes by which we're defining new weaponized capabilities. And so I think I'll leave it there as a segue to some of the other technologies and conversations we'll have. But I want to thank Leah and Walter for their opening provocations for today.
Provocations.
Thank you.